Good morning. It's a pleasure that we have so many students and faculty this afternoon and in some parts of the world this evening. This first workshop, which is really about the Nuremberg framing of those principles that was codified in 1950, have endured over some 8 decades, particularly after World War II and the Nuremberg trials, which was really the global understanding of war, ethics, and international law. And this has significantly transformed in response to criminal actions of nations such as Russia and China, and recently the United States of America. The pre-20th century Old World Order, which will be elaborated by my colleague, Professor Susanna Fisher, has faced serious challenges since the Great War of 1914 to 1918 and the establishment of the 1928 Kellogg-Briand Pact, which renounced war as a national policy. The renunciation caused an understanding which was not completely understood in terms of the state's responsibility to act upon such illegal actions. And following that came the atrocities of the Nazi genocide. But leaving this aside and for our speakers to elaborate, I just wanted to share that these 3 workshops scheduled for this spring semester for both faculty and students are comprising joint efforts by Susanna Fisher and me of the Catholic University of America, Professor Roman Svedo of Jackie Lorisky University, and Professor Piotr Petu of Taras Shevchenko National University of Kiev. And this is about examining what is happening in terms of the framing of the Nuremberg Principles in the 21st century. So there will be key questions arising, and I look forward to our discussion. Now to the speakers. They are Professor Michael Basler, who is a professor of law and the 1939 law scholar in Holocaust and Human Rights Studies. He's a holder of previous fellowships at Harvard Law School and the United States Holocaust Memorial Museum in Washington, D.C. He's written enormous amounts of articles and chapters, and he's a world-renowned expert on the Nuremberg trials and human rights. Followed will be his very reverend, Mittered Archpriest Mark Morozovich. He graduated summa cum laude and joined the Catholic University of America, first teaching and quickly becoming the Associate Dean for Seminary and Ministerial Programs, which was promoted very soon to Dean of the School of Theology and Religious Studies. He is currently the Bishop Basil Lostin Chair of Ukrainian Church Studies and Director within the Eastern Church Christian Studies. He is enormously important in bringing an international, or rather religious dialogue between the Ukrainian Orthodox Church and the Roman Catholic Church. And last is Professor Robert Destro, Professor of Law at the Catholic University of America's Columbus School of Law in Washington, D.C. He's been a member of the CUA Law Faculty since 1982, served as interim dean from 1999 and 2001, and the director of University's Institute for Policy Research and Catholic Studies from 2017 to 2019. In the domestic sphere, Professor Destro has been an advisor to churches and religious organizations from a variety of religious traditions. His remarkable work in the first Trump administration really focused on issues related to freedoms of speech and human rights. So with these introductions, I'd like to turn this over to my colleague, Professor Susanna Fisher. Thank you.
Thank you, Professor Regenbogen. I would like to thank everyone who helped us to make this workshop possible, despite Mother Nature conspiring against us, especially Professor Regenbogen, our three distinguished panelists, Professor Piotr Fedo of the Jagiellonian University, Professor Roman Petyur of the Tarashchenko University in Ukraine, our marketing and communications director, Joe Ferraro, Al Washington, our web design and content manager, our media services director, um, Greg Stack, our assistant director for student life, Renee Stack, Dean Payne, Dean LaBelle, our assistant dean, Gemma Forrest, Constantia Dedulis, the director of the Law School's Institutes and Special Programs, and the president of the International Law Student Society, Jennifer Rodriguez. I would like to thank all of the attendees, and I'm particularly grateful for the presence of CUA students, faculty, and staff, and from those of you who are located across the United States and in Ukraine and Poland. For CUA students who would like an ethics credit, I have attempted to put the link to the Google form that you need to fill out into the chat. And if you can't see that, please respond to the chat and we'll get that to you. I will now very briefly set the stage. The Nuremberg Principles were a response to the failure of the, quote, old world order, as I would call it, of international law and international relations to prevent the rise of totalitarian regimes that disregarded the freedom and dignity of the human person by causing terrible wars and committing numerous crimes against humanity. For many centuries prior to the 20th century, wars of aggression were viewed as a sovereign right that could be legally and morally justifiable. Waging war was an acceptable activity in ancient times and was a way that many civilizations like the Romans, Mongols, and Huns built their empires. The prevailing ethos was might is right. The victors in war generally considered that they had the right to punish the defeated by sacking cities, seizing cultural property as spoils of war, enslaving or abusing conquered populations, and killing enemy prisoners. In the 17th century, some jurists, notably Hugo Grotius, responded to the horrors of the 30 Years' War by seeking to promote moderation and justice in warfare, grounded in natural law and the jus gentium, a voluntary customary law based on the consent of sovereign states. For Grotius, aggressive war could be lawful if it was rooted in and proportional to a just cause, which could include retaliating against a wrong that was already committed or preempting an anticipated attack. But the total war and horrendous atrocities that the world experienced in two 20th century world wars severely challenged Grotian principles. Starting after the First World War and especially after the Second World War, the international community sought to promote a world of peace by shifting the focus from international sovereignty to individual accountability for crimes against peace, war crimes, and crimes against humanity. The seven Nuremberg Principles from 1950 summarized this new world order, as I would call it, in an elegantly short and simple document. For almost 8 decades after the Nuremberg Principles, the world's major powers have not gone to war with each other, and no UN member state has ceased to be a state as a result of conquest. But now, in the 21st century, we're witnessing a rise in cross border conflicts and a growing tendency by some national leaders to unilaterally use force against other states, such as Vladimir Putin's invasion of Ukraine. What is the role of the Nuremberg Principles for international law and the international world order going forward? We invite attendees to collaborate in our discussion of these issues to the extent possible in this Zoom format. Please submit your questions while the panelists are speaking and during the Q&A period by writing in the Q&A area in the Zoom. And we also invite you to email us after the event with your thoughts and questions. This will help us to refine the next two workshops that follow on from this one. And my email address is Fisher at cua.edu. I would like to turn the floor over to our first panelist, Professor Michael Basler.
Oh, okay. I'm unmuted right now, correct?
Correct.
Okay. All right. So did you hear what I just began, or should I just go ahead and start all over again?
I think you should start all over again.
Okay, sure. So I just want to say thank you, Professor Fisher, for inviting me. I very much have enjoy every opportunity to talk about Nuremberg and the Nuremberg trials and the legacy of that. And this year is really a special year because we are commemorating the judgment of Nuremberg that occurred exactly 80 years ago. So let me start with just the basics. I'm a law professor, and so the students that I teach come into my classes with various levels of knowledge. So Nuremberg is a city in Bavaria, in southern Germany. Now it stands for much more. It's also the birth of modern international criminal law. And the way that came about is because during the Nazi era, it was considered to be the favorite city of Hitler. It was the one where the Nazi party rallies were held. Hitler came into power in 1933, and World War II ended in 1945. The other reason was because after Germany was defeated, Germany was then divided into four zones, and the American zone happened to be in Nuremberg. And the Allies had a very important question to decide. What do we do now that the war is over? And you've got, just in Europe, between 40 to 50 million people have died, 40 to 50 million. 20 to 25, 25 to 30 were civilians, and 15 to 20 million were military personnel. Just think for a moment, these are really staggering numbers. It's the worst conflict in human history in terms of the number of deaths. And Europe was really in pieces. And so one of the things that was discussed, let's take the leaders of that promoted this, the higher rank Nazis, and just shoot them. Hitler was no longer alive. He committed suicide. But there were other Nazis, that high-ranking Nazis, that either surrendered or found out. But the United States, leading this effort, said, no, if we do that, then what we're doing is the same thing as the Nazis. We want to have a trial, and we want to put on trial these war criminals, all Germans, Austrians, for the crimes they committed between 1933 and 1945. And we're not going to put them on trial under domestic law, German law, or the law of the countries where they committed the crimes. We're going to put them on trial under international law. And the tribunal will be created called the International Military Tribunal, the IMT. So, and we're going to put together for the first time an international criminal court. It's an ad hoc court to do a very specific job in order to judge the guilt and innocence of these individuals. It was very important for the Americans to not have this as a show trial. The chief prosecutor was Justice Robert Jackson, who was a justice on the U.S. Supreme Court, took a leave of absence from the Supreme Court to come to Nuremberg and to put together both the trial and the court itself. And I'll give you the end result. There were 22 defendants that were put on trial. 19 were found guilty, but 3 walked out of the courtroom. And these are high-ranking Nazis. And the reason they walked out of the courtroom is because, according to the judges, or at least the American judge and the British judge and the French judge, the prosecution could not prove guilt of these three high-ranking Nazis beyond a reasonable doubt. They were tried for other crimes later on. They could be tried under domestic law, but in that particular case, it was not. And that, I think, to me, is one of the important legacies of Nuremberg and why it's remained so important. Because it was a trial in which, within a short period of time, between November of 1945 and October of 1946, the trial took place. All of the defendants had attorneys. The attorneys had access to all the documents. Everything was translated. And we ended up having justice, real justice. The crimes that the individuals were put on trial is ones that Professor Fisher already mentioned. The easiest crime that they could be put on was war crimes. By this time, war was already considered to be not a free-for-all where anything is possible. And that came from the legacy of World War I and the various treaties like the Hague Convention and the Geneva Convention that basically said that a war is not a free-for-all and that there are certain things during the time of war you cannot do. You can't just shoot civilians. You can't destroy cultural monuments. You can't just go ahead and, when you have prisoners, just shoot them because they have the status of prisoners of war. And that would have been the easiest charge and could have been the only charge. But the prosecutors decided to add other charges. The second charge was crimes against humanity. And that term never came up really as part of any crime. Now, between 1933 and 1939, Hitler was in power. World War II did not start until September 1st, 1939, with Germany's invasion of Poland. So all those acts committed by the Nazi regime between 1933 and 1939 would be crimes against humanity. I'm making this very basic to understand the differences. The third crime was, the crime of aggression, crimes against peace. The fact that war, when you wage an aggressive war, that is illegal. As Professor Roggendagen had mentioned, there was a treaty during the interwar years between World War I and World War II, the Kellogg-Briand Pact, by which nations signed and agreed not to use war as an instrument of deciding conflicts. But that particular treaty had no provision for any kind of a criminal prosecution, how you do this. It basically was a promise by the various countries. But it was that Kellogg-Briand Pact and the other customary international law that was used as precedent to create the crimes against peace. And so these individuals were put on trial. The prosecution divided the different crimes in which they would argue. So the Americans took, one of the crimes, the British took another crime, the French took another crime, and the Soviets took another crime. And they put on their case. And after the case was finished, and they put the prosecution case on, the defendants ended up taking the stand, and they could go ahead and argue their guilt or innocence, and they would be cross-examined. And that process was done. For those of us looking at that process that went on between November 1945 and October 1946, it was an amazing feat in such a short period of time what these prosecutors, could accomplish, what these judges could accomplish. On October 1st, 1946, actually 2 days, September 30th, 1946, and October 1st, the judgments or the verdicts were read out by the judges. And basically, as I mentioned, that other than the three defendants who were found at least not guilty for these particular charges, the other defendants were found guilty, and they ended up getting different sentences. At that point, the death penalty was still considered to be as part of the punishment, and therefore some of the defendants received the death penalty, and it was carried out. Other defendants were put in jail, and then at a certain point in time, they either served the full sentences or the sentences themselves were commuted or shortened. Now, what happened as a result of this is the Nuremberg trials ended. It's an ad hoc tribunal. It's finished. The judges go home. After that, the Americans held 12 more trials in their American zone. And they didn't have international judges. They had American judges come. The other victorious allies also had trials, but it's the later Nuremberg trials, plus the original IMT trial when we talk about Nuremberg. And when the trials ended, what do we do with that? And what we did is 1950, we ended up creating these Nuremberg Principles that basically stand as kind of the groundwork for what international criminal law would be. Now, Nuremberg, when I began first teaching many years ago, was just history. It was something that we had talked about, it happened, but this was during the times of the Cold War. You could not have the international community, like the United Nations, create another tribunal. There was talk of the original dream of creating a permanent international criminal court, but again, that could not be done. When the Soviet Union collapsed, and the Cold War ended, there was much more greater cooperation. And so the Security Council ended up creating further tribunals on the model of Nuremberg to judge international crimes committed in other parts of the world. The two most prominent were the crimes that were committed after the dissolution of Yugoslavia, and that was the International Criminal Tribunal for Yugoslavia, or the ICTY, and the 100-day massacre, genocide that occurred in Rwanda in 1994, and that became the ICTR. These, like Nuremberg, were ad hoc tribunals. They did their job. They ended up looking at the guilt or innocence of each defendant. By that time, capital punishment has been abolished. And they're basically, today, there's just few cases left over from that. But then in 1998, the international community came together, and outside the framework of the United Nations, but alongside of it, in Rome, under the Treaty of Rome, created the first permanent international criminal court and used the Nuremberg model. So when we speak today about Nuremberg, it's not just a city in Bavaria. It's a place where we as lawyers, as jurists, pay homage to. I tell my students, if you are Muslim, you have to make an annual, a one-time pilgrimage, at least in your life, to Mecca. If you're Jewish, you go to Jerusalem, all right? But this is, Nuremberg is the place, I think, where every lawyer should make a pilgrimage to in order to see where it occurred. Courtroom 600, where the trials took place, is still there. You can get a tour. You can go to the Palace of Justice that still has the four flags outside: the Soviet flag, what country no longer exists, the British flag, the American flag, and the French flag. And then you're able to see in the Nuremberg Principles Academy, a tour, an understanding of what Nuremberg was all about. I'm looking at my time. It looks like it's 10 o'clock. I've spoken for about 15 minutes. I can stop right now. As you can imagine, I can speak for hours and hours on this. One last point. At this law school, on March 19th, we are screening the film Nuremberg. And I'm very, very glad that this feature film is now being shown. And the new generation, individuals, law students, undergraduate students, are now recognizing, knowing what Nuremberg is about. So I make a plug. If you have not seen Nuremberg, the film, with Rami Malek and Russell Crowe, playing the chief defendant, Hermann Goring. Highly recommend that movie. I think it's very well done, and I'll stop here.
Thank you, Michael. So may I ask that Professor Father Mark, please take the next presentation.
Thank you so very much, Dr. Regenboog and Dr. Fisher, for organizing this opportunity to get together, this opportunity to raise awareness, to raise the question of where is international law today. For my part, I'll just be speaking briefly about some of the theological, but as well as helping to broaden people's understandings of the church's stance and really how the church looks at this concept of war, just war, defense, and all of these things in general, but really looking at the specific history of what has happened in Ukraine. As you were talking, and I believe that we've seen this background of the Nuremberg trials as an important indication of society's willingness to organize and call to accountability perpetrators of crimes against humanity. I find it a bit awkward and challenging, even as we look at the role of the Soviet Union in the Nuremberg trials themselves, because it seems to point to the fact that no one at that point was ready to hold the Soviet Union to task for the 1932-33 homicide of people in Ukraine during the Holodomor, the starvation of over 6 million people, the deportation of people into the Gulag, and almost contemporaneously with the establishment of the Nuremberg commissions and what they were doing, the arrestation of the entire hierarchy of the Ukrainian Greek Catholic Church in 1945, and then in 1946, the liquidation of that church, the imprisonment of thousands of faithful because they were witnessing to a difference, witnessing and willingness to be free. So I think that the questions of freedom of law, the questions of a freedom and dignity of human beings is at the general basis, and asking ourselves in this context of a legal forum, where are we on this path today? In 2014, Vladimir Putin was angered at the manifestations of the citizens of Ukraine when the then president chose to ignore a path toward unity with Europe, and they manifested and eventually overturned the president Yanukovych at the time. He then left the country, went to Russia, and a new election was held. About that time in 2014, there was the beginning of the war. Everyone talks about the full-scale invasion in 2022, but we must see that the war began in 2014 with the illegal annexation of Crimea and the war that's festering still today in the Donbass area. This is a flagrant violation of the Budapest Memorandum signed in 1994 by Russia, the aggressor in this case. It was also signed by the United States and the United Kingdom, in which it agreed to recognize the territorial integrity, political independence, and not to use weapons against Ukraine. So since 2014, this war has been waged illegally, unjustly, and immorally. So when we look at the basic foundations and understandings of human dignity, if you have never had the opportunity, I invite you to look at the document Gaudium et Spes from the Second Vatican Council. The document outlines a view about the free determination of people, the free determination of choice of religion, the free determination of choice of government. And this is ingrained in what the church points to as natural law. This idea that God has created the world and endowed in everyone, and maybe popularly we talk about this, even the sense of a conscience. And so the church at that point, the Catholic Church, in Gaudium et Spes, directed, and this is something that we don't talk about enough, directed this document not to Catholics, not to Christians, but to all people. It's making a profound stance and statement that each person, regardless of who they are, is to be afforded the human dignity to live their lives in accord with how they desire. So the 2014 invasion was completely illegal. The world stood by. The signers of the memorandum in 2014 were basically feckless. In 2022, the world stood by as they expected Ukraine to fold under the might of the mighty Russian Empire. In 2026, today, on this 29th day of January, the people of Ukraine continue to fight and manifest for their freedom. They are defending themselves against an aggression that is steeped in history of seeking to eliminate Ukrainian identity, Ukrainian culture, and a freedom of self-determination. There is an important document that you can read on March 5th, 2024. The Ukrainian Greek Catholic bishops of Ukraine issued a reflection on this reality, and it's looking at rescuing the victims from the hand of the oppressors is the actual title. It's a letter of the Synod of Bishops of the Ukrainian Greek Catholic Church on war and just peace in the context of new ideologies. It's easily findable on the web. It counters directly a Russian-inspired and Russian Orthodox-inspired concept called Ruski Mir. The basic tenets, and you can find this by Googling, you can find it in the original Russian on the Moscow Orthodox Patriarchate's website today. And it basically talks about the Russian world extends beyond the confines of the Russian nation. And it has the ability then to take care of people and impose, in a sense, its will upon people wherever, because they view it as their right. So this is a decidedly distinct, aggressive stance. This is a stance where it is looking at people in the West and wants to be the people who are bringing about the safety for the world, because they view themselves as the only ones who are preserving true Christian identity and are really holding up against the evils of the West. If you've never read it, do take a time, because this helps us to understand what is really afoot. Vladimir Putin, in many different addresses, has decried as the worst tragedy of the 20th century being the dissolution of the Soviet Union. These are stances that have been taken that are clearly amoral, that are against human dignity, and that continue today. It was interesting, as we heard in the introduction, we were talking about some of the principles of war. If you do an analysis today, you can see that the very principles of war that we've talked about, especially through the Geneva Convention, are being absolutely and completely disregarded in Ukraine. Currently, today, almost 2,000 residential high-rises lack electricity in Kiev. Thousands of innocent people's homes throughout Ukraine have been bombed. In the occupied territories, thousands of people have been deported and arrested. Churches, mainly Protestant, Evangelical, Baptist, Ukrainian Greek Catholic, have all been dissolved, their property taken from there. And there are some great films that I can share with you as well, and we'll hopefully do a few screenings at the university so that we can learn and be more aware of the very crimes and atrocities against humanity. So when we think about the whole movement, if you will, we can see that what is happening now is a continuation of a track of an aggressive state against a population that comes from the very beginnings of the 20th century and even earlier, to the very rise of the Tsardom in Muscovy that completely looks down upon the people of Ukraine. So it's not my point to go into the entire history, but I thought it was important to have this as a sort of a basis to see that what is happening today is rooted in a deeper history, that what is happening today contravenes the Budapest Memorandum, that what is happening today is contrary to the Geneva Convention. And so recently, as of, and let me get the exact date here, as of January 14th, 2026, the Ukrainian Council of Churches and Religious Organizations calls for the world's attention that the deliberate, systematic, and massive daily attacks using dozens of ballistic and cruise missiles and hundreds of UAVs against cities of Kiev, Odessa, Kharkiv, Dnipro, Sumy, as well as other cities and villages, is indeed crimes against humanity, terrorism, even in oblasts that border Poland. And so that is a quick overview of how these situations are being looked at. And this, I should mention that this Council of Churches is a interfaith reality where Jewish leaders and the Tatars and Muslims and various of the different Christian faiths have all gathered together and are witnessing in freedom. So I'm just about at my time, and I wanted to just bring these to you to think about some of these principles about the human dignity and about what is happening in Ukraine today, and to see in some extent parallels to the lack of human dignity, to the crimes against humanity that we have just been discussing. Thank you very much.
Thank you very much, Father Mark. It's one of those tragic eras where we have cultural genocide in Ukraine. And the presentation you made certainly brings effect. And if someone wants to read this chapter by Father Mark, it is in the book, The Nuremberg Principles and Ukraine, and the Contemporary Challenges of Peace, Security, and Justice. And for students in the law school, it's in the law library and was also selected as prerequisite for reading before the conference. And again, Michael Basler has set the tone of how such tragedies as what we are experiencing in Ukraine was also experienced in Germany, called the Holocaust. And again, these are very important venues to understand how much effort by the church, by religion, and by secular organizations and people are trying to change the crimes that we are witnessing today. And for that, I'd like to introduce Professor Robert Destro, who has not only the academic understanding, but the practical praxis of having worked in the field under the first administration of President Donald Trump. Bob, would you be so kind and make your presentation?
Sure. Thank you, Herb. And I want to start with a word of thanks to you, Herb, and to Susanna Fisher for your work in organizing the webinar. And perhaps unbeknownst to most of the people in our audience, the work you're doing to bring the Nuremberg Principles to the world's attention. I mean, there's a big conference coming up next year, which I hope you'll talk about a little bit before we're done with this. And because they're really important in ways that sometimes are not obvious. I'd also like to thank and talk about how honored I am to be on the podium with Professor Baszler and Father Morozevich. Their excellent work, leading up to, and the writings they've done is a real eye-opener. And I hope that all the students and other people actually take some time and immerse yourself in it. Let me talk a little bit about the perspective I'm going to bring to this, and then talk about one of the points that Father Morozevich mentioned a little earlier, which is the human dignity part. I bring to this table, as Professor Regenbogen said, as I'm a human rights litigator and I'm an advocate. I'm now involved in the proceedings of an international tribunal governed in part by the Nuremberg Principles and by local domestic law. So I see what litigation looks like from the inside. I was an assistant secretary of state for democracy, human rights, and labor at the State Department from 2019 to 2021. And in my role as a senior diplomat, because in that role I was in charge of all the federal government's international human rights programs and funding, I was always involved in regular discussions about the delicate relationship between the active and aggressive enforcement of international legal principles and, quite frankly, that which is the often murky diplomatic consideration that encourage political settlements, sometimes at the risk of truncating or even eliminating the international part of international criminal proceedings in favor of a more local resolution or diplomatic resolution of issues of both guilt and remedy. And then also in my capacity, I guess as a government, you would call me a government bureaucrat. Part of my remit at the State Department was to administer around $1.5 billion in foreign assistance funds, some of which were spent on documentation of genocide, war crimes, and crimes against humanity for later and ongoing prosecutions. And so I have a sense of what three writers actually called the prosecutor NGO industrial complex. So I understand how that works. And also as a law professor who teaches and writes in the areas of constitutional law and human rights, legal ethics. And I reference my background here because it's so easy sometimes for academics and human rights advocates like me to view the horrific crimes that produce indictments in international criminal tribunals as matters to be resolved at law. My other experience caution, that the establishment and enforcements of the Nuremberg Principles are only the beginning of the discussion. And we have to be cognizant that these principles must be applied in a manner consistent with international human rights norms. So I'm going to go back and mention what Father Morozevich talked about, which is the human dignity part of this equation. And, one of the great academic insights I had during my time as Assistant Secretary of State was to focus on, and I did a lot of work with the Organization for Security and Cooperation in Europe. And we did a lot of work. We met with a lot of people from Crimea, with people from Ukraine. This was obviously before this part of the war started, because the war didn't really start in 2022. It actually has quite a long history. And if you look in the Organization for in the OSCE literature, you'll see references to what we call the human dimension, of security. And since, OSCE is a spinoff of NATO, you say, well, what human dimension relates to what? Well, you've got the physical dimension, which is the battlefield. You've got the operational dimension, which is the strategy and effectuation of war or defense. And then you've got the human dimension. I mean, how does this affect people? And that, I think, is the thing that gets lost. So that when people ask me, well, what do you want to do when you go back to academics? I said, well, I want to stay involved in things, but I actually want to see if we can't put the human dimension back into human rights discussions, because oftentimes we talk about the rights, but we don't talk about the human dimension of those rights. And so let me begin, with Professor Regenbogen asked me specifically to look at questions like freedom of speech and how does that affect things. I want to let me start by talking about the ways in which freedom of speech, freedom of association, freedom of religion, the right to petition for redress of grievances, all of those things are bound up in the issues, some of what people might call to deliberately quote Vladimir Putin, but to talk about the quote root causes of this war. What we have, people have called the great wars in Europe as European civil wars. And so we look at the question of the human dimension when we look at speech, for example. Speech is something, communication is something that's inherent in the person. Our desire to understand the transcendent, that's where our rights to freedom of religion come from. Our understanding of who we are as individuals and who we are as a community is bound up in this right of freedom of association. And when we see that something has gone wrong, that's when we want to stand up and say, wait a minute, somebody's got to stop this, and somebody has got to be held accountable. And one of the things that's so brilliant, I think, about the Nuremberg Principles is that at a very human level, they express the desire to hold people accountable for their behavior. And all of us have had the experience as children of being put in timeout, or worse sometimes, for bad behavior. And the insight that led to the Nuremberg Principles is that just because you run a country doesn't mean you're exempt from being held accountable. But we do know that because the world is organized right in nation states, there has been a long discussion of what's the relationship to nation states, to these international tribunals and international organizations like the International Criminal Court, the United Nations, OSCE, all of these different things. And And what I'd like to leave the for our discussion is the fact that in all of this, as we look at the Nuremberg Principles and as we try and apply them, we have to understand that we're engaged in a very human endeavor, and that as a diplomat who had to often negotiate, as I said, those often murky ways of trying to figure out how do you resolve a conflict, and understanding that an international criminal tribunal might actually make the conflict last longer. Now that was a real eye opener for me when you say, well, look, let's have an agreement, and by the way, we're going to try you and hang you as a war criminal once you make an agreement. I mean, those are real considerations that a lot of times the academic literature doesn't really talk about all too much. So I'm going to leave it at that and open up, give it back to you, Professor Regenbogen and Professor Fisher, and hopefully open up the floor for discussion.
Thank you very much. I enjoyed your presentation, and I think that we should not lose much time. So I'd like to give this over to Professor Fisher and to engage our students and if there's faculty as well. Thank you.
Yes. So if you could ask any questions, if you could put them into the Q&A feature that you'll see at the bottom of the screen. I'm not sure if the chat was disabled for a while, so I think the Q&A is preferable. I do have one question here that Professor Phillips has asked, and it's addressed in particular to Professor Baszler. He says, how do you respond to critics of the Nuremberg Tribunal as an example of victor's justice? In your view, does this critique have resonance with regard to contemporary international justice efforts, or have there been some instances of so-called comprehensive justice? Professor Baszler, did you hear the question?
Pardon me, I was muted. Okay. So can you hear me now?
I can, and you heard the question.
I heard the question. I did. Okay. So let me say this. I don't know the term comprehensive justice. The term victor's justice is a term that was known at that time, at the time of the Nuremberg trials. And this is specifically what the British, American, and French wanted to avoid. So for me, the biggest proof that in fact it was not victor's justice is that 3 defendants walked out of that courtroom because the prosecution, according to at least the Western judges, could not prove guilt beyond a reasonable doubt. And I think that created an important precedent. If it was just like I'll use the term informal kangaroo trial, show trial of the kind that Stalin was doing, right, it would not have carried, the kind of legacy that we have with the Nuremberg trials today.
Thank you. And now we have another question coming from Ukraine, from Mr. Kiriltsev. And he says, I would like to thank the panelists for a very profound and interesting discussion. I especially appreciate the extensive attention given to Ukraine. Adding to the discussion, I was wondering what your thoughts are on the future special tribunal on Russia's aggression against Ukraine and the international compensation mechanism for Ukraine. Recent developments on the basis of the Council of Europe are promising. So any panelists who would like to address that question?
I would like to address it. I don't want to, it's a great idea. And when I said it's easy for academics, especially I sat with great interest listening in on a symposium held in 2022 on exactly this topic. How are we going to hold the Russians accountable? And I kept thinking during the whole time, you and what army are going to hold them accountable? And so, if you go back to the question that Professor Baszler was asked about quote unquote victor's justice, from the perspective of a diplomat, who has been involved in discussions like this, the idea that there's going to be a special tribunal on Russia's aggression and international compensation mechanisms for Ukraine, that's certainly a possibility. I know it's a profound hope for a lot of people, but good luck getting the Russians to participate in them. And unless you can, and in this regard, when you have the perpetrators in custody, it's much easier when that you have them running sovereign states, and there were an awful lot of very, very interesting issues that never really got raised, with respect to Allied behavior during World War II as well. So I would say uh, I'll believe it when I see it, and I'm not optimistic.
Perhaps I might add something to what Professor Destro said. Since this court is, as of the beginning of this year, in operation, which means that taking those Russians and trying them in an international court, again, underscores the legacy of Nuremberg. And this is important because, again, this is not a kangaroo trial. And again, the very Nuremberg Principles are addressed. Impartiality. The idea that you have to listen of these alleged crimes. They're not crimes by itself. They are alleged war crimes. And that's the importance of a court. And this international court is now looking at international war crimes, whereby, and again, back to Professor Destro's comments, how do you deal with the leaders? Well, again, in this agreement with the Council of Europe and Ukraine, those leaders, in this case, the Russian President Putin, the Secretary of State, and the Minister of the Interior, are exonerated until that time when they are no longer in office. And for many people, they will remain in office because it's a totalitarian government. So again, this is, I think, is an important part of that agreement for the new court in The Hague for crimes of aggression, war of aggression.
And if I could just, just sort of looking at a global perspective, where are we with our peace organizations, with our ability to really have memorandums of understanding? If there are no ability to enforce these, as we saw with the Budapest Memorandum, well, I'm not sure what engages people further, and then we end up with just a might is right fight. And I think that, looking at where law is and how law functions is an important thing for us to be engaging further. And I don't have any answers, and I don't purport to, provide any here today, but I think that it's an important consequence of holding the principle of human dignity. And how do we engage with our brothers and sisters throughout the world who are living in places where the human dignity is not upheld?
This is another question that, excuse me, came from a student in my public international law class. They submitted questions in advance. And this question is, where do you think the Nuremberg Principles fell short, if at all? What principles do you think should be expanded or added?
Well, let me just say this. I think they did a very good job. I would stick with the ones that are there. I don't think that they've been in existence since 1950. And so we need to go ahead and strengthen them, use them, teach about them before doing any kind of amendments to them. Think they, in very succinct text, really put the legacy of the trials into those principles.
Yeah, I would completely agree with Professor Basler on that. I mean, I think that there's a real human dimension to those principles, and it's basically accountability. I mean, nobody disagrees that there ought to be accountability. The question is, how do we actually operationalize it? And so when we look at the requirements of due process, I know the law students will chuckle when I say this, but how does the court get jurisdiction over the defendants? And on what basis does it have jurisdiction to apply the international law as well as the domestic law of the places where it sits? So it seems to me that you don't need much more by way of principles. The principle is accountability, and law is out there already. Those crimes against humanity are pretty clear. So I don't think we need to add any more. And so now the question is, how do we work together to ensure that the law is not only uh, applied fairly, but it's also perceived to be applied fairly?
Yes, and there's a question that spoke to that. It's attendee. How would you respond to the argument that it's victor's justice if only the losing states are being prosecuted for crimes that the other side also committed or commits today?
Well,
Well,
yeah, please
I'm
go
sorry,
ahead.
go ahead.
No, go
No, no,
ahead.
please.
Well, the U2 defense was not specifically, set out that it could not be used during that time. I think it really goes back to the basics of criminal law, which is, if someone is before a judge and the defendant says, no, 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 but look, all these other people committed. And why are you putting me on trial? That's not what this is about. It's like, the parent, where the child says, no, 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 but I'm not the only one. Look at all these other kids that did that. You have to make a decision based upon the individuals before you. And that's why I began with the statistics of how many people were murdered. Okay. That's on them. Those are the perpetrators. And these are those 22, were the highest ranking Nazis that were put on trial.
And I would, I completely agree. And, but I think the question, how come only the losers get prosecuted? I would sincerely hope that we could get beyond that one of these days. And because again, if the principle is accountability, then we have to look at behavior, at human behavior. And we know, as a matter of fact, that a lot of people get away with murder. I mean, that's just the way things work. You can't prosecute everything, but the victor's justice question does raise the question about, well, wait a minute, are we only talking about people who run nation states like Vladimirovich Putin, and Georgia Maloney and Donald Trump and whomever, are we only talking about them, or are we talking also about people who run proxies, people who run proxy wars, and people who support proxy wars? I mean, I bent over backwards. I wrote a lot and advocated a lot for a declaration of genocide, for Congress to basically say, look, we want the people who run ISIS to be accused of genocide. We did the same thing with respect to the Chinese treatment of the Uyghurs. I worked on that when I was at the State Department. The idea that you're actually going to bring people to justice is an aspiration, but we have to do what we can do in the meantime.
If I could just remark very quickly, you take Germany at the time of the Nuremberg trials and the 12 others. Many thousands, tens of thousands of Germans that were known to the Federal Republic of Germany when these courts were transferred over to the government to prosecute, many of them were rehabilitated, especially the judges. They were Nazis, and they were rehabilitated and got their pension. So they lived their life out like anyone else. And then there were so many because the statute of limitation was about to run out until a German jurist by the name of Bauer began to want to prosecute German war criminals. And that became the Auschwitz trial. So again, this is the fundamental issues. How do people who are knowledgeable of an international crime react to the truth? And they don't react. They run away from it until their children, like in the case of Germany, started asking very uncomfortable questions to their parents and to the government. And again, this is about a next generation, a consciousness, an identity. And I think this is very important when we talk about the issues of how we deal with criminals besides the leaders, as an example.
And actually, there's another really good film, a German film that came out in 2019 called The Collini Case, Der Collini-Fall, that speaks exactly to these issues. And it's based on a book by a German criminal lawyer, von Schirach, who was a descendant of the von Schirach, who was the head of the Hitler Youth. So very interesting film for all of you to watch. So I wanted to give you another question. This is from Albert Bulter-Brisov. In your view, to what extent were defense lawyers at Nuremberg able to exercise their role as independent legal representatives within the procedural framework of the tribunal? More specifically, how should we assess their contribution to due process and the development of international criminal procedure, given the structural constraints and historical context in which they operated? And I might throw in also, if you could give consideration to the Tokyo the tribunal, the International Military Tribunal for the Far East, where Americans, as well as Japanese lawyers, served as defense lawyers, whereas I think in Nuremberg, it was only Germans who served as defense lawyers at the IMT in Nuremberg.
Well, I'll take
Well,
it. Yeah,
go
please
ahead.
go ahead.
No, you have more experience on this
No,
part.
no,
I
no,
was
no.
going to talk about contemporary stuff.
I don't want to go first, so please take this one, and I'll go ahead and I'll comment afterwards. I think you and I are doing a very good job back and forth on this. So please go ahead.
Yeah, I mean, I think it's an excellent question. There's another question in there that I want to weave into this, and that is you have to have defense counsel. Otherwise, you do have a kangaroo court. I mean, you have to have aggressive, well-prepared, and I might add, very well-financed defense lawyers, because it's not cheap to put on the defense, and it's not popular to put on the defense of a war criminal or an alleged war criminal. I will kind of, and having been involved in a couple of these cases, one involving the International Criminal Court, another one involving Yugoslavia, I can tell you that the pressure is enormous. And so in answer to your question, how should we assess the contribution to due process? I think the stories of those defense counsel really need to be emphasized. They need to be told. We need to understand how much it actually costs to mount a defense. That's something that is that's not talked about much, but it is, at least in a federal indictment, it's about $1.5 million per count to defend yourself, and that's the low end. So I do think that the defense counsel are absolutely essential, and I think the distinctly American and British contributions here has been in that adversarial sense of what a defense looks like.
Yeah, let me also just add that when Eichmann was put on trial in Jerusalem, and he was given the choice of who he wants defense counsel, he chose one of the defense counsels from Nuremberg to fly in 1961 and to go ahead and defend him.
Um, so we have another question here coming from a student. Is the International Criminal Court doing enough to vindicate the Nuremberg Principles?
The International Criminal Court is not in a good place right now, unfortunately. It's being attacked by the Trump administration. There are sanctions being put against some of the judges, some of the individuals. It's, the current government in the United States, if it had the choice, it would just completely get rid of that court, not having it available. And that's really a shame because the United States was one of the parties that signed on to the ICC. It did not take the second step, which is bring it before the Senate and confirm that particular Treaty of Rome. But I think with certain administrations, when it's necessary, we did reach out. I hope that this child, and still a child, okay, is not smothered in its teenage years and exists as a full adult. It plays a very important part in international criminal justice.
I would add to that I would recommend. There's a very interesting article by Salvesberg, LeBranch, and Phillips called "The Prosecutorial NGO Complex," and it talks about opportunities and structures and the role of international NGOs in universal jurisdiction trials on Syria. And I'll put the reference to it in the chat. But having been involved in these cases as a lawyer, you have to be very cognizant about the fairness of the court. And there have been lots of allegations about the ICC and just how independent it is, about the politics of the prosecutions. I can say, from having been involved in cases where you have international NGOs on the other side, there are some real interesting and serious due process and legal ethics questions involved. But that you have those problems in every court. And so the question is, how do we make the court, if you're going to have it, assuming you're going to have it, then you have to make it truly independent. But if it's truly independent, then you run into to what one author, the former president of the University of Pennsylvania, called the horns of a dilemma. You have a truly independent court, which then has no connection to the nation states, that really organize most of our international understandings of things. So this is a very kind of who's actually the judge and what community is actually doing the judging is kind of deeply embedded in that ICC question.
And that is really the dilemma that we're facing in terms of the New World Order. Are we going backwards? I mean, the whole issue of the international organization, particularly the ICC, is that it has to be transparent and not dependent on any body whatsoever, just like Nuremberg was not dependent. And that comes to the question of the future of international criminal law. Is it useless, or will it become something very effective to change what is going right now on in terms of going backwards with not respecting international criminal law? Look at it. I mean, attacking a sovereign state, whoever the leader might be, or whoever he might have committed crimes, he's still a sovereign. He has immunity until such time where he can be criminally accused or warrants of arrests. This was not the case. The country was simply invaded, just like Russia invaded Ukraine. That would be the argument. And that is really something that needs to be addressed. And this is why the question of the future of the Nuremberg Principles and how will they develop? Will we lose them, or will we sustain and reinforce them? And how? And that depends on how the states, the major states like the United States, commits itself for the first time to the rule of law and not just cherry pick.
And there was a question that relates somewhat to that about as international law, criminal law expands beyond traditional conflicts to address cyber attacks, autonomous weapons. How should the Nuremberg Principles and/or international criminal law evolve to remain a meaningful foundation for international criminal responsibility in light of 21st century technology?
Well, part of it, I think, and this is where uh, I'd like to ask Father Morozovich too, in terms of where, what is the moral requirement, the kind of the human dignity part, where does justice fit into this, and who's obligated to see that it gets done from that perspective?
Well, of course, the short answer is that we're all responsible, all as members of humanity, and and the ways that we find to bring those entities to responsibility, I think, are what we're in the midst of today. I think that the more that we have conversations, the more that we engage, the more that we see, well, if you're going to have true human dignity, the flourishing of the human being, that it involves us, finding ways and structures and creating, institutions. And I think we have some examples of those. And I kept thinking that throughout this, I mean, even if we look at the Nuremberg, as I raised the challenge earlier, how is it that the Soviet Union was able to be there and stand in judgment whenever it committed some of the same crimes against humanity? And yet there wasn't a political will, there wasn't the ability. I mean, I don't know, exactly what the historical answers are to that. People say they didn't know, this was all covered up, but I mean, we have CIA documents that prove that there was knowledge of these things, knowledge of these deportations, knowledge of these arrests. And so, in some way, I think it's a pragmatic type of thing. Well, what can we manage to do? And what are we able to do as human beings? And so I think it's a grave call to us. It's a grave call that people that I issued as well about the Budapest memorandum. If in 2014 there wasn't a decisive reaction, and it was being tested in the resolve of the international community. So ultimately, in some ways, it's up to each of us, and that's why I think the United States is such a wonderful country in that we have this ideal of the rule of law, and we test it and we prod it and we move forward and backward, and I think that it's up to us, it's up to every human being to share that, to develop that, to develop this respect for one another, this approach that creates worlds create spaces of human flourishing. So I don't know if that was very satisfying, Bob, but I think it's something that ultimately is up to each of us in our own little ways. And then as we work together and we work with our incomplete, temporary sort of modes of bringing about this justice, but that we continue that large arc that brings people to a greater sense of justice and build those institutions forward.
No, you gave me exactly what I was looking for. Thank you. Now, the reason I say that is that one of the things we tend to often think about judges when we think about courts. But when you think about criminal courts, and I invite the law students in the audience to look at the ABA standards on criminal justice, and those are, and especially the ones involving the obligations of the prosecutor, because no prosecution anywhere starts without an indictment, or an information. And all of the factors, how much evidence do we have? Can we make it stick? What should we charge? I would spend 4 of my initial classes in professional responsibility looking at the role of the prosecutor, and people would say, why? I said, because he's the only person in the whole system whose obligation is to see that justice is done. And one of the things I waited all during law school to listen to when we're going to have a real discussion of justice, it never came. We got procedure and jurisdiction, but we didn't get justice.
You're still muted, Suzanne.
This should work now. We are approaching 2 o'clock, and I know that some at the law school and elsewhere have classes, including myself, that begin at 2. I and others may have to leave now. If anyone wishes to stay, Professor Regenbogen, I think, can monitor the Q&A, and I don't know if the panelists need to leave at 2 or can stick around for a little while. But I would like to just thank everyone for your participation in this really interesting and I think important discussion, which is to be continued at 2 future workshops, one in February and one in March, which we will be publicizing, as well as the conference in 2027. So we very much hope that you will all join us for those events, to continue this discussion at those opportunities. And thank you and goodbye to you for today.
Thank you very much.
Okay, I will also say goodbye.
Okay.
I'm very glad to participate.
I'd just like to thank everyone for being here. And if you have any questions, please send them through the chat or otherwise an email. And again, thank you very much and have a wonderful day.
Yes, and my thanks to all as well. I have another obligation that I have to get to, but it's been a privilege to be part of this and look forward to engaging in further discussions.
Thank you
Thank you.
all.
Thank you.